Pam Bondi thought she had already outlasted the worst of it. She was out of the Attorney General's chair. The subpoena was written for a sitting cabinet official and she was no longer that. The argument was ready. The legal framework was ready. Her team had spent weeks building a wall around her testimony, job title changes, official capacity arguments, letters from the Justice Department explaining why the old obligations no longer applied to the woman who used to run it. And for a few weeks in April 2026 that wall held. She did not appear on April 14th, no communication, no coordination, nothing. And then a federal judge asked one question: this is not a story about procedural delay. This is not Democrats performing outrage and Republicans covering for the administration and both sides walking away with the same talking points they walked in with. This is about what happens when a court-supervised legal process collides with a former attorney general who believed she had already escaped the room. The question the judge asked was not complicated, it was one sentence. And when Bondi's legal position came face to face with that one sentence inside a framework that does not run on press cycles or party loyalty, something cracked open that no letter from the Justice Department can close back up. Here is what you need to understand. The Epstein Files Transparency Act passed Congress 427-1. That is not a partisan margin, that is a mandate. The law carried a legally binding disclosure requirement and a deadline of December 19, 2025. The Department of Justice, under Pam Bondi's direct leadership, released roughly 1% of what the law required. 1% out of the full federal archive on the most consequential sex trafficking investigation in modern American history. And the question the judge is now forcing her to answer is the question that 1% was designed to prevent. Let's go back to where this actually began, because the judicial intervention happening right now did not arrive from nowhere. It is the downstream result of a chain of events that started before Bondi ever sat down at that hearing table on February 11, 2026. In July 2025, President Trump directed Bondi to seek court approval to unseal the grand jury transcripts in the Epstein case. The Southern District of New York had been overseeing grand jury materials related to Epstein's prosecution for years: sealed documents, witness testimony, FBI interview summaries, evidence records that had never entered the public record. A federal judge in that district was already supervising a process to determine what could be released and what had to remain protected under grand jury secrecy rules. When the Epstein Files Transparency Act passed in November 2025 with overwhelming bipartisan support, 427-1, and Trump signed it into law, it created a second track of legal obligations sitting parallel to the court-supervised process already underway. The DOJ was now bound by both a federal statute and the court's oversight framework. Both said the same thing: release the files, full disclosure, every document. In December 2025, the DOJ released what it released. Members of Congress who tracked the disclosure identified it as roughly 1% of the required material. Rep. Thomas Massie, who co-authored the Transparency Act, called it a massive failure. Senate Minority Leader Chuck Schumer called it a cover-up. And the judge in the Southern District of New York, watching a legally mandated public disclosure process produce a fraction of what the law required, began asking questions of his own. The documented record of what Bondi's Justice Department did and did not do with the Epstein files is specific, it is date-stamped, it is named, and it is exactly what the federal court oversight process is now drawing on. On December 19, 2025, the DOJ missed its statutory release deadline. What it produced was so heavily redacted it was, according to multiple members of Congress who had previewed unredacted versions in a secure DOJ room, functionally useless for understanding the scope of the Epstein network. File F-0000468, the photograph found inside Epstein's personal desk drawer at his Manhattan mansion, went live on the DOJ's public website on a Friday afternoon and disappeared by Saturday morning. The index jumped from file 467 directly to file 469 as if 468 had never existed. No announcement, no explanation. No statement from the Attorney General's office about why a legally mandated public disclosure had silently vanished from a government website overnight. When the file was restored 2 days later, Deputy Attorney General Todd Blanche said the DOJ had removed it due to concerns about victims depicted in the photograph. The photograph was reposted without any redactions. The DOJ's own statement said, after review, there was no evidence that any Epstein victims were depicted in it. That is not a sequence of events that resolves cleanly. That is a sequence of events that a court supervising a transparency mandate is now required to examine on the record. Then came the February 11, 2026 hearing. The burn book Pam Bondi arrived at the House Judiciary Committee with a binder containing the printed search histories of members of Congress who had visited the DOJ's secure reading room to review the unredacted Epstein files. 4 computer kiosks. No phones, DOJ employees standing directly behind lawmakers watching every search term they typed. Rep. Pramila Jayapal called what Bondi brought into that hearing room a burn book, a printed log of exactly what members of Congress had been looking for inside the files the DOJ was supposed to release to the public. Speaker Mike Johnson, Trump's most loyal congressional ally, told reporters that tracking lawmakers' searches was inappropriate. He said he would echo that quote to anybody involved in the DOJ. In March 2026, the House Oversight Committee subpoenaed Bondi directly. The vote was 24-19 bipartisan, with 5 Republicans joining every Democrat on the panel. Rep. Nancy Mace moved the subpoena. Rep. James Comer, the Republican chairman, sent a formal letter stating that the committee had questions about the DOJ's handling of the Epstein investigation and its compliance with the transparency. Bondi's April 14 deposition date came and went. She did not appear. And then on May 7, 2026, U.S. District Judge Kenneth Carras of the Southern District of New York released a document purported to be Jeffrey Epstein's suicide note. The judge's ruling did not establish the note's authenticity. It established something more significant for the accountability process currently moving through the courts. It found the document was a judicial record subject to the public's right of access. That ruling is a signal, not because of what the note says, because of what it confirms about the legal framework Judge Carras is applying to the entire Epstein documentary record under his supervision. When a federal judge operating under a transparency mandate rules that a document is a judicial record subject to public access, it directly addresses the central legal argument Bondi's Justice Department has been making for months, that certain materials can remain withheld, redacted, or quietly removed from public access without triggering compliance obligations. The question the judge is now forcing into the record is the one that every delay, every redaction, and every missed deadline has been constructed to avoid. Why did the Department of Justice, operating under a court-supervised disclosure framework and a federal statute passed 427-1, produce 1% of the legally required material? Not approximately, not roughly, 1%, that is the one question, and Bondi walked out of the room before answering it. Here is what walking out actually looked like. It did not happen in a single dramatic moment. It happened in layers. The April 14 no-show was the first layer: no communication, no coordination, a spokesperson's statement from the Justice Department explaining that the subpoena had been issued to an attorney general and Bondi was no longer one. Rep. Robert Garcia of California responded to that argument the same day it was made. Our bipartisan subpoena is to Pam Bondi whether she is the attorney general or not. The second layer was the March 18 closed-door briefing. Democrats on the House Oversight Committee walked out of that briefing in public, on camera. They told reporters Bondi had refused to answer key questions and would not commit to testifying under oath. That is the Attorney General of the United States, still in office at that point, declining to answer questions from Congress about the legal compliance obligations of the department she ran, in a closed-door setting with no cameras and no public record. Think about what that means. When the cameras are on, Bondi calls democratic questioning theatrics. When the cameras are off, in a room where nothing will be reported unless a lawmaker walks out and tells the press, she still refused to answer. The question that Judge Carras's court is now pressing into the official record is the question that the April 14 no-show and the March 18 walkout were both designed to delay, and a federal judge is not a congressional committee. A federal judge does not respond to press releases. A federal judge does not accept the argument that a subpoena expires when a job title changes. A federal judge operating a court-supervised disclosure process over grand jury materials in the Epstein case has the authority to compel answers that no congressional letter, contempt threat, or political calculation can override. That is the wall Bondi is now standing in front of. Here is what this means legally, because the stakes here are precise and they build on each other. The court-supervised Epstein grand jury process in the Southern District of New York has been running parallel to the congressional oversight investigation for months. These are two separate legal frameworks. One is a court supervision of sealed judicial records. The other is Congress's constitutional oversight authority over the executive branch. Both are now pointed at the same question about the same documents handled by the same former attorney general. When a federal court asks a question in a court-supervised process and the answer involves conduct by a former senior official, that official does not have the luxury of citing job title changes. Personal capacity arguments, executive privilege assertions, and deliberately delayed deposition schedules apply to congressional proceedings. They have a much harder time standing up in front of a federal judge who is already supervising the underlying document record. The DOJ Inspector General has announced a formal investigation into whether the agency complied with the Epstein Files Transparency Act. The Government Accountability Office, at the direction of Sen. Jeff Merkley of Oregon, is conducting a separate probe. The civil contempt resolution filed on April 29, 2026, 45 minutes before Republicans announced the May 29 deposition date, is in the permanent congressional record. Both can be true at the same time. The deposition is scheduled and the contempt record exists. What the judicial process adds to this picture is something that congressional oversight does not have on its own. It adds the compulsory authority of a federal court over a sealed record that predates Bondi's tenure, that exists independently of her job title, and that the court has already signaled it considers subject to the public's right of access. You cannot walk out of a federal judge's question the same way you can skip a deposition. Here is where this goes from here, and both paths lead to the same place. If Bondi appears at the May 29 deposition and answers questions under oath about her handling of the Epstein files, those answers enter a record that already includes the 1% release figure, the File 468 disappearance, the burn book, the 24-19 subpoena vote, and the March 18 walkout. Whatever she says will be placed directly beside everything that is already documented. Inconsistencies between sworn testimony and the documented record are not a political problem. They are a legal one. If Bondi does not appear on May 29, if there is another no-show, another legal argument, another letter from a new official claiming the old obligations have expired, the Republicans who currently have enough cover to call the contempt resolution theater will lose that cover. The 5 Republicans who voted for the bipartisan subpoena will face a direct test, and the federal court process, which does not wait for congressional scheduling negotiations, will continue moving regardless of what happens in the deposition room. Read that last part again. The federal court process will continue moving regardless. That is the part that changes everything about Bondi's position right now. Congressional oversight can be delayed by changing job titles, missing deposition dates, and sending lawyers to file privilege arguments. Court-supervised grand jury processes move on a different timeline with different authority and without the political buffer that allowed Bondi to no-show on April 14 without immediate consequences. Every door leads to the same room. The files are still not fully released. The co-conspirator list is still redacted. The IG investigation is running. The GAO probe is running, the court is asking its question, and Pam Bondi's name is attached to all of it. Maria Farmer reported what she knew to the FBI in 1996. She described what had happened to her and her younger sister at Jeffrey Epstein's properties. Her account went into a file, the file entered a system, and for years nothing came back. On February 11, 2026, Epstein's survivors sat in the gallery of the Rayburn House office building while the Attorney General of the United States refused to face them. Rep. Pramila Jayapal asked them to raise their hands if the Justice Department had never contacted them or met with them. Every hand in the gallery went up, every single one. They have been waiting for 30 years, for some of them longer. The names are still hidden, the accounting is still owed. The court that is now asking its one question is asking it on their behalf, whether it frames it that way or not. Here is what the next 30 days look like. May 29, 2026 is the deposition date. The DOJ Inspector General report on Transparency Act compliance is moving toward completion. The GAO probe is parallel and ongoing. Judge Carraz's court in the Southern District of New York has established that judicial records in the Epstein case are subject to public access, and that framework now extends to the question of what the DOJ did and did not produce under its legal obligations. When Bondi sits down in that deposition room on May 29, no longer as Attorney General, no longer protected by the institutional machinery of the Justice Department, no longer carrying a binder full of other people's search histories, she will be a private citizen answering questions under oath about decisions that are now simultaneously under congressional investigation, Inspector General review, GAO scrutiny, and federal court oversight. That is not one question. That is one question asked from 4 directions at the same time. The room she walked out of is still waiting, the judge's question is still on the record, and on May 29 the door opens again.